भारत में इस समय राजनीतिक व्यवस्था में एक सबसे बड़ा जजमेंट लगातार चर्चा में है, वो है मनी लॉन्ड्रिंग को लेकर जो सुप्रीम कोर्ट का फैसला आया है, जिसमें ईडी के अधिकारों को लेकर सुप्रीम कोर्ट ने तमाम बड़े फैसले दिए हैं और जिससे लगातार एक बार फिर से बहस गर्मा गई है उस कानून को लेकर। ईडी यानी कि इन्फोर्समेंट डायरेक्टरेट की शक्तियों को लेकर, उनके जिस तरह छापामारी, गिरफ्तारी और जब्ती, तमाम विषयों पर हमारे साथ अमन लेखी साहब जुड़ गए हैं, जो सुप्रीम कोर्ट में सीनियर एडवोकेट हैं, इससे पहले फॉर्मर एडिशनल सॉलिसिटर जनरल रहे हैं और एक लंबी प्रैक्टिस है। अमन सर, सबसे पहले तो पहली प्रतिक्रिया, सुप्रीम कोर्ट के 3 सदस्यीय बेंच ने जो पीएमएलए को लेकर अपना फैसला दिया है, उसको लेकर बड़े वाद विवाद शुरू हो गए हैं, तो आपकी पहली प्रतिक्रिया उस फैसले को?
देखिए, पीएमएलए में एम्बिग्विटीज थी, इनकंसिस्टेंसीज थी, एंड मोर देन एवरीथिंग एल्स एक इन्वोकेशन को लेकर सजेशन अब्यूज था। Invocation will be abused because of the ambiguities and inconsistencies. और लॉ का वर्थ आता है उसकी क्लैरिटी, उसकी सर्टेनिटी एंड उसकी कंफॉर्मिटी विद फंडामेंटल लीगल प्रिंसिपल्स।
जी।
द मैनर इन विच द एक्ट इज एनैक्टेड, आई फील इट ऑफेंडेड कंफॉर्मिटी विद दोज प्रिंसिपल्स। इस करके चैलेंज हुआ, और जब चैलेंज होता है तो it is the responsibility of the court to settle the law. I feel in declaring the law, certain aspects in the judgment do not deal with it as clearly as and as comprehensively as it should. और मेरा मानना है कि one, to the extent interpretation of money laundering is concerned, what the interpretation the government sought and what the court upheld, it is inconsistent with the terms in which Section 3 is drafted.
ठीक है।
And moreover, even the international conventions on which reliance is placed, if you read those conventions, 2 things are important. One, in terms of the convention itself, this interpretation, in my opinion, may not be, in my opinion, the right interpretation. Of course, the law is what the Supreme Court declares. And number 2, in any case, while जो interpretations होती हैं international conventions की, they have significant value where application of interpretation etc. is concerned, but they cannot override the section. And the section actually spoke a language which is different from the perceived interpretation the conventions put. And in that context, the so-called explanation जो section 3 में थी, which has been upheld to be an explanation, in my opinion, did not in fact justify its description and explanation, because explanation clarifies, elucidates the substantive provision, as the word explanation itself suggests, but this in fact substituted it. And for that reason it fell foul of the substantive provision and could not actually be recognized as an explanation. The court, however, has felt that the explanation is in fact explanatory, because according to the court, mere possession is money laundering. I do not think possession by itself, possession in circumstances the intent is to eventually launder, may be money laundering, but it is an activity which can be involved in it. But to say that just holding it without anything more will amount to money laundering, in my opinion, may not be correct. 1. 2, as far as provisional attachment is concerned, to hold that there need not be an FIR, relying on the second provision, in my opinion, again, is not, strictly speaking, in my opinion, an interpretation which will uphold, because the purpose was, आप उसके खिलाफ भी प्रोसीड कर सकते हैं जिसके खिलाफ मनी लॉन्ड्रिंग का केस नहीं है जी, पर इसका ये मतलब नहीं है कि शेड्यूल्ड ऑफेंस ही नहीं होना चाहिए, बिकॉज द क्वेश्चन इज प्रोसीड्स ऑफ क्राइम, और प्रोसीड्स ऑफ क्राइम कब आएंगे? प्रोसीड्स ऑफ क्राइम तब आएंगे तब एक शेड्यूल्ड ऑफेंस हो, और शेड्यूल्ड ऑफेंस इमेजिन किया जाएगा, scheduled offense होगा ना, there has to be a scheduled offense. Therefore, there has to be proceeding dating scheduled offense. And the absence of that, to say that yes, we can provisionally attach even without, may not be correct. I mean, I have my reservations where this opinion is concerned. That's my opinion. The court, what the court has said is the declared law. Now, 5 will have to be read. This is again a thing. Now they talk about presumption. Now, where presumption is concerned, I broadly agree with what the court has said, because वुल्मिंगटन का रूल है, वुल्मिंगटन का रूल एब्सोल्यूट नहीं है, सब्जेक्ट टू स्टैट्यूटरी एक्सेप्शंस, बट जो एलुसिडेशन हुई है लॉ की, उस पर क्लैरिटी इस चीज की आनी चाहिए थी, क्योंकि जब प्रिजम्पशन की बात करते हैं, वी टॉक अबाउट एविडेंशियरी प्रिजम्पशंस एंड वी टॉक अबाउट the legal presumption, that is onus of proof as to the matter of evidence and onus of proof as the matter of law. Now onus of proof as the matter of law always rests on the prosecution. This is what broadly the Supreme Court has actually said, but not clearly in these terms. Now as far as 24 is concerned, it's an exception. Now I'm talking about the first part of section 24, where the person is accused of money laundering, not the second part, which is discretionary. But insofar as the first part is concerned, what should be very necessary is, and the court has also said, the foundational facts have to be proved. If foundational facts have to be proved, the onus shifts. But that is one part of it. The onus shifts. So, what is the level of proof required to discharge the onus? Now, if it is evidentiary burden, right, that means the legal burden will remain on the prosecution.
Correct.
And the legal burden will remain on the prosecution, and then it is for the prosecution to discharge that burden. Now, that this bill, you can interpret it in some way, but there is an ambiguity. Because there is an ambiguity, the question of clarity which led to this particular litigation was very necessary, which is
और मुझे लगता है जिस पॉइंट को आप उठा रहे हैं वही लार्जली एक लोगों के मन में आ रहा है, क्योंकि लगातार इस जजमेंट के बाद लोग जो कमेंट्स कर रहे हैं वो तो सीधे तौर पर कर रहे हैं, एक तो हम ही फंसे, हम ही प्रूव करें।
नहीं,
हाँ,
वो आप बोलिए जी। Presumption of innocence is a fundamental principle.
Correct.
Onus is on the prosecution is undisputed. There can be statutory exceptions. मैं दूसरी तरह से बात कर रहा हूँ। 24 is a statutory exception. The reason for that is that certain things may be in the knowledge of the accused. Because they are in the knowledge of the accused, the onus is on them to bring that information. Now that information will be brought by them, but the eventual onus to prove the case is on the prosecution.
बिल्कुल correct.
That cannot be. Now this has to be settled with clarity, because it's an evidential and not a legal burden, right? Which had to be said with a fair amount, because जब ये onus of proof की provision आती है, तो ये देखा जाता है, वन, कि क्या एक element of offence इसका प्रूव करना है, पूरा offence प्रूव करना है, टू, circumstances in which ये प्लेस किया गया है, थ्री, the possibility on the accused to discharge the burden. आप एक burden नहीं डाल सकते accused के ऊपर जो incapable of discharge हो। अगर वो incapable of discharge हो तो वो कभी disprove कर ही नहीं पाएगा। So you have to see कि भैया is it possible for that person to discharge, and four, is it a proportionate interference with Article 21? These are basically four. Now ideally the court should have said these things out and explained it in that manner, and then जो ये criticism आ रहा है, that criticism would have been addressed कि भैया see this is the principles, we are conforming to the principle in this way, and this is the way in which we proceed. But the problem यहाँ है is not so much of the principle. Problem यहाँ आ रही है, उन्होंने बोला है चार्ज के बाद ओनस आएगा, प्रूफ आएगा। Now उसका मतलब जब 5 की प्रोसीडिंग्स होंगी और अगर चार्ज तो है नहीं उस टाइम, मे और मे नॉट बी अ चार्ज इन द ऑफेंस, राइट, उसका मतलब ओनस नहीं आएगा, तो उसका मतलब 8 में भी नहीं आएगा। तो इसका ये जो कॉन्ट्रडिक्शन है कि भैया अगर इफ यू आर गोइंग टू से कि 24 के अंदर चार्ज के बाद आएगा, तो 5 और 8 का क्या होगा? 5 इज प्रोविजनल अटैचमेंट, 8 इज फाइनल अटैचमेंट। तो उसके अंदर क्या दैट द पर्सन हु इज प्रोसीडेड अगेंस्ट उसको प्रिजम्पशन नहीं है, वेरी गुड, वो तो बड़ी अच्छी चीज होगी, उस प्रिजम्पशन उसके अंदर होगी ही नहीं, पर ये होगी कि नहीं होगी इसकी क्लैरिटी, when you read the judgment of the whole, there is a possibility of ambiguity, and therefore in the ambiguity there will be you will exploit it, there will be further litigation. Now when there is further litigation, the purpose of declaration will to that extent be undermined. So these are things which can, of course, वकीलों के लिए तो बड़ी अच्छी बात है कि as this aspect is concerned. So this issue which is a very live issue and a very important issue.
As far as bail is concerned, उसको लेकर एक बड़ी ये हो रहा है कि अब और ज्यादा टफ सुप्रीम कोर्ट के आदेश के बाद हो जाएगा, उस पर आपको क्या कहना है?
You see, as far as bail is concerned, the Supreme Court, to the extent it said, violation of 13 doesn't efface the law.
ठीक है.
Because it does not efface the law exists, and you can therefore alter it. Now they go into Validation Act. I have my own reservation whether this principle of Validation Act is correct, because I don't see this as a validating act, because the validating act of the discipline is completely different. The reasoning of the Supreme Court, to the extent it upholds 45, in my opinion, has got a few issues which are open to a contrary interpretation, which is equally valid, because the manner in which 45 has been reenacted,
correct,
could have been done better. and because it could have been done in a better manner, it was appropriate for the court to actually, because the purpose of a court is to rein in the executive. that is जो जुडिशियल रिव्यू होता है, जो कोर्ट की स्क्रूटनी होती है, कोर्ट की स्क्रूटनी होती है टू कीप द पावर होल्डर्स इन चेक, बिकॉज इट इज अब्यूज ऑफ पावर which is to be restrained by rule of law. And rule of law eventually is what in our system what is declared by the Supreme Court. So एक ये sacrosanct duty है, because eventually the worth of our liberties lie in the declaration by the Supreme Court. Because the worth lies in the declaration, there requires to be an element of circumspection in the dealing and clarity in the exposition. Because if there's an oversight on a relevant principle or an omission in the declaration, maybe an accidental or innocent omission, then the statement of law detracts from a certain statement which is capable of giving clear guidance. वहां रोल ऑफ द कोर्ट जो है वो आता है.
हाँ जी.
और इसके अंदर जब अ कोर्ट इज नॉट गोइंग टू बॉदर, आई मीन मेनली बिकॉज लोग बोल रहे हैं कि भैया ये है, मैं आई डोंट सब्सक्राइब दैट ओपिनियन. आई डोंट फील दैट यू accuse the court of intentional wrongdoing, right? What the court has held is an opinion drawn from the facts as it stand and not the arguments as are drawn. I will never attribute a motive to the court. You can't possibly attribute, and that the view of the court is a possible view. My problem is in the way in which it is expressed, which gives rise to unfounded statements about the declaration.
Correct.
That is the only thing which has to be done. Now 45, where 45 is concerned, there's a basic infirmity in 45, because I'll explain to you. As far as 45 is concerned, not guilty. Everyone is right. This is a very high standard. We are not guilty. Up at the threshold. How will you say not guilty? But then question is, when you interpret a provision, you have to interpret a provision in the context in which it is to operate. So the level of the threshold for the purpose of deciding not guilty would not be the final threshold at the stage of conviction, but the threshold would be on the prima facie reading of the evidence. Now the prima facie reading of the evidence, जो the onus जो आता है बंदे के ऊपर होता है कि भैया आई एम नॉट गिल्टी. यहाँ जो मैं पहले बता रहा हूँ उसके अंदर गिल्टी का ओनस है प्रोसिक्यूशन के ऊपर, बिकॉज मेरा ऊपर तो एविडेंशियल बर्डन है. यू कैन येट मेक आउट अ केस दैट on the evidence as stand, that is not, because it's not been argued like this ever, on the evidence as it stands, it's not guilty. You can जैसे बोलते हैं it's a higher threshold on a prima facie case, मैं तो बोलता हूँ you can turn it around to the benefit of the accused to say that भैया you cannot show that guilt is there at all, but we leave that aside for the time being. What is wrong with it? Illegal arguments aside, ये जो provision normally होती है, this follows what is a pre-trial inquiry, जिसके अंदर थोड़ा कोई एविडेंस वगैरह लीड होता है, जिसके अंदर आप एक प्राइमा फेसी व्यू कर सकते हो कि भैया गिल्ट है कि नहीं. उसी बेसिस के ऊपर आप कुछ टेंटेटिव फाइंडिंग पे आ सकते हो. ये टेंटेटिव फाइंडिंग की फाउंडेशन एट द टाइम ऑफ बेल नहीं होती, एंड वी हैव एन एक्यूजेशन, एंड बिकॉज इवन एक्यूजेशन सिंप्लिसिटर, एंड वी आर नॉट एट अ स्टेज, द सुप्रीम कोर्ट हैज सेड दैट द ओनस इज on the accused to show कि भैया ये गलत है. वो तो स्टेज आई नहीं, राइट? तो अगर ओनस अक्यूज के ऊपर है कि वो मटेरियल लाएगा, चार्ज के स्टेज तक भी आप मटेरियल नहीं ला सकते, बेल उससे पहले का स्टेज है, तो मैं गिल्ट को एड्रेस कैसे करूंगा?
करेक्ट.
You cannot, there is an inherent contradiction here. When you deal with the provision, apply it across, you have to understand कि भैया एक का असर दूसरे पे कैसे होगा, और टोटलिटी में स्टैट्यूट चलेगा कैसे. ये चीज मिसिंग है. आपने एक चीज पढ़ी, फिर दूसरी चीज पढ़ी, फिर तीसरी चीज पढ़ी, पर ये जो चीजों के जो इंटरमिंगलिंग है, जो इंटरडिपेंडेंस है, जो एक होल कॉन्स्टिट्यूट होना चाहिए, इसके ऊपर उसके ऊपर क्या इंपैक्ट होगा, ये मिस हो गया. आपने 3 किया, 5 किया, 24 किया, 45 किया, 44 किया, पर इनकी इंटर रिलेशनशिप क्या है? आपस में चलेंगे कैसे? एक मैटर किस तरीके से आगे बढ़ेगा, उसमें कैसी चीज होगी, ये चीज मिस हो गई। अब जैसे बेल में ये रिक्वायरमेंट है ना, they are judgment of Supreme Court which have modified the rigor of provision like these, right? But nevertheless, it is a provision which is, in my opinion, still suspect, because the standard of reasonableness which will justify applying Menka Gandhi, in my opinion, is absent in this particular provision. More so now on the basis of the interpretation itself. On the very interpretation the Supreme Court has said makes this provision utterly suspect, because there is no means with the person to actually say that he is not guilty, because वो तो आएगा भैया, तो मैं एविडेंस रीड करूंगा, तो आएगा, तो मैं कैसे करूंगा? तो मैं तो परपेचुअली अंदर रहूंगा जेल के अंदर।
करेक्ट।
ये तो चल ही नहीं सकता। ये चीज पहली चीज। दूसरा, इट वाज ऑब्लिगेटरी, इट्स वेरी डिफिकल्ट। इसके अंदर क्वेश्चन है, इट इज बेस्ड कंप्लीटली ऑन द सब्जेक्टिव सैटिस्फैक्शन ऑफ द कोर्ट। अब गिल्ट यह है या नहीं, ये एक सब्जेक्टिव ओपिनियन है, और ये टोटली सब्जेक्टिव है, क्योंकि स्टेज इज एंटीरियर टू ट्रायल, दैट मींस मटेरियल एविडेंस इज एब्सेंट। तो ये सब्जेक्टिविटी को कंट्रोल कैसे करोगे? एक वन सब्जेक्टिव ओपिनियन वुड बी गिल्टी, another subjective opinion will be not guilty. But what is the norm which distinguishes the guilty part from the not guilty part? वो norm नहीं है। अगर norm नहीं है तो provision गलत है, क्योंकि how do you identify the criteria to conclude the basis of the grant of bail? If you don't have the criteria to conclude the basis,
correct,
that itself that will fall foul of 21, because it will be no procedure which law can actually warrant to contemplate. Now this is something which should have been examined. Right, should have been argued and examined, and should have been. Why should we blame? As far as the process is concerned, the process has to be. It is interactive between the court and the lawyers. Whether it was presented like that, I don't know. But it is absent as far as this particular the judgment is concerned.
बिल्कुल, आपने बहुत अच्छी इसको इंटरप्रिटेशन किया। मुझे एक लास्ट बता दीजिए सर, मैं बिल्कुल अंतिम प्रश्न कर रहा हूं आपसे। क्या आपको लगता है कि PMLA के जरिए एक पेंडोरा बॉक्स खोल दिया है सुप्रीम कोर्ट ने?
नहीं, जब भी लॉ होगा, वकालत होगी, कोर्ट्स होंगे, तो पंडोरा बॉक्स हमेशा खुला रहेगा। तो सुप्रीम कोर्ट ने कोई पंडोरा बॉक्स खुला नहीं है। बॉक्स बंद हो सकता था किसी तरीके से, पर अभी बंद नहीं हुआ है। सो वो बंद होके भी बॉक्स खुल सकता है। तो जैसे 19 है अरेस्ट का, जो प्रोविजन है, दो चीजें मैं सिर्फ बताना चाहता हूँ। वन, जो रिगर्स ऑफ 19 are far higher than ordinary law. So 19, the way it is drafted, right, is the protection against arrest. But what is very important is this is many times abused. And here the role of the court is very important, because पहला कोर्ट जब आता है वो ट्रायल कोर्ट आता है 19 के लिए।
करेक्ट।
अब हर एक चीज के लिए आप रिट पे तो जाओगे नहीं, और रिट पे जाओगे समय निकलेगा, बंदा तो अंदर है। The rigorous implementation of principle of 19 should have been set out specifically in the judgment, because and should have been pointed out that 19 is a protection to an accused, and because the protection to an accused, insofar as compliance with the requirements concerned, is sacrosanct, and a breach will lead to immediate release. So this has to be this was because 19 and 41 को देखा जाए CRPC के अंदर, 19 is a much more stringent provision, because वहां है suspicion ऑफ ऑफेंस, आप अरेस्ट कर सकते हो। कॉग्निजेबल ऑफेंस हुआ, आप अरेस्ट कर सकते हो। यहां नहीं, यहां जब तक आप गिल्टी नहीं सोचते, तो ये एक प्रोटेक्शन है, दैट इट इज अ प्रोटेक्शन शुड हैव बीन ड्रिल्ड इनटू द जजमेंट, दैट सी यू कैन नॉट अरेस्ट इजीली हो जाता है। वन दिस, टू, ये जो सेक्शन 50 की बात है, आर्टिकल 20, मेरे हिसाब से ये बोलना कि भैया ये रिकवरी की प्रोसीडिंग्स हैं, इज मिसिंग द पॉइंट in many ways, because yes, one aspect is a hybrid kind of an act. It has got one aspect which is recovery, the other aspect is penal. Now there are other ways in which you can justify 50. Article 20 नहीं violate हो सकता, you can, because जो remit है 20 का relevancy पे नहीं आता, confession के ऊपर आता है, और वो सवाल पे डिपेंड करता है कि जो आप आर्टिकल 20 को वायलेट करेगा कि नहीं। सुप्रीम कोर्ट ये बोल सकता था कि देखो ऑन अ केस टू केस बेसिस, Article 20 may or may not be violated. But Supreme Court can't say that Article 20 cannot ever be violated. Because Article 20 can be violated too. And to say, relying upon certain judgments, that as far as the scheme is concerned is different from NDPS is again, I feel, because I had argued Tufan, and I don't think the court was right in Tufan Singh judgment, not because I had argued to the contrary, but I just have a different principle. But nevertheless, Tufan Singh is the law. Now, you have to distinguish Tufan Singh to reach a contrary conclusion. But you can't say that the scheme of PMLA is different from NDPS because the punitive aspect is common to both. And as long as punitive aspect is common to both, you cannot go to the scheme. And in my opinion, reliance on Customs Act or reliance on FERA is also not correct because the scheme of those acts is equally different from PMLA. And that was the reason why the Supreme Court in the earlier judgments had actually said that देखो 20 वहाँ नहीं apply करेगा, 20 वहाँ नहीं apply करेगा. Supreme Court ने बोला कि scheme of Customs Act was different, but you cannot bodily lift from those judgments something to say PMLA. So there are various issues. आप पंडोरा बॉक्स की बात करते हैं. These are various issues which I feel will remain live still. And on the basis of the judgment itself, you may be in a position to argue like, as far as virus is concerned, the virus has been upheld. 3 will be a bit of an issue now because of the way in which the question is done. There can be various advantages which will be inadvertently conferred on the accused. It was not, may not have been the intent of judgment because of the reasoning of the Supreme Court, and benefits which can yet be exploited notwithstanding the judgment. So I don't see the scenario to be very bleak. Lawyers will be able to find out from the judgments how, because eventually what is supreme is the Constitution, and that is a fundamental law, and the primacy of that law cannot in any way be belittled by anything, and any ambiguity which has to be solved has to be reconciled keeping those principles in mind. And I feel we can yet today read this judgment to make it conform rather than just be resigned with dejection to say that actually all doors are shut where legal process is concerned.
Correct. आप यंग लॉयर्स हैं या इस जजमेंट को लेकर आपके दिमाग में तमाम प्रश्न थे, वो कहीं ना कहीं अमन सर ने एड्रेस किए हैं और बिल्कुल साफ तौर पर कहा है कि जो टोटलिटी में इस जजमेंट को कहना चाहिए था वो शायद अधूरा है, और कहीं ना कहीं एक बड़ा पेंडोरा बॉक्स खुला है जो तमाम चीजों को भी लगातार करता रहेगा. और सही बात तो यह है कि अदालत और वकीलों का काम ही है कि उसको और बेहतर तरह से क्लैरिफिकेशन दे. नीचे इसी वीडियो के एक ईमेल दिया हुआ है, फिर भी आप बतौर वकील, आप बतौर किसी भी तरह से विक्टिम हैं तो इस ईमेल से आप संपर्क कर सकते हैं, सीधे अमन सर से सवाल पूछ सकते हैं कि आखिर इसके बाद की स्टेज क्या होगी. बहुत बहुत शुक्रिया अमन सर, बहुत बहुत धन्यवाद. नमस्कार.